The following program is made possible in part by the Dayton Bar Association.
Welcome to the 2018-2019 season of You and the Law, a public service program in which we address current legal issues in our greater Dayton community. This is a live call-in show on a monthly basis. The phone number here is 937-223-5311. And it may be viewed on television on Channel 5, Spectrum, in the greater Dayton area. That's also in Riverside. Channel 6 on Spectrum in the northern suburbs. And although there seems to be a little debate over this, we'll clarify this as best we can through the Miami Valley Cable Council, Communications Council, on Channel 23 or Channel 991 on Spectrum in the southern suburbs. The program has historically been live streamed since we've had live streaming, but there's a changeover going on, coincidentally, just this evening, between Ustream and Cablecast. That means we may or may not be able to present this on live streaming tonight. If not, it will be available starting tomorrow, I'm told, on YouTube. And you would go to YouTube, search, and the search bar, put in Dayton TV or DATV, and follow the prompts with the spyglass that will take you to You and the Law, this program. I hope that's helpful. It's my first night, as you'll learn in a moment, and we'll do our best. Our show is brought to you by the Dayton Bar Association and Dayton Access Television, better known as DATV. At different points in tonight's program, we will repeat the information I've provided as best as we can, and maybe add some additional information, some phone numbers as we go along. My name is Jeff Swillinger. I'm an attorney in the Dayton area, and I'll be your host and moderator this season. Michael Monta, your former host and moderator for over the past 26 years, will be taking some well-earned time off this season. Although I'm hopeful that Mike will join us later in the year and sit across the table from me as our guest later on in the season, as I said. I would like to join all of those associated with this program right now in thanking Mike for his devotion and outstanding years of service to this program and to the greater community we serve through the vehicle of public access TV. Tonight, the subject of our program is landlord-tenant law in Ohio. Our focus will be on the residential side of this topic rather than the industrial and/or commercial side of this area of the law. Our guests tonight are Debra Lavey and Steve Katchman, two very fine attorneys who practice primarily in the greater Dayton area. Now, I welcome both of you to the program, Deb and Steve.
Thank you.
Deb, I'll ask you first to tell us a little bit about you, your background, and your familiarity with tonight's topic, and then Steve, it'll be your turn, and then we can move into the substance of the show. Deb?
So it's my pleasure to be here, Jeff. Thank you for asking me to be on the show. So I'm an attorney with Advocates for Basic Legal Equality. We're a sister organization with Legal Aid of Western Ohio, and often known as Legal Aid. And we're a nonprofit law firm that serves low-income individuals in civil matters, including landlord-tenant issues. So it's a pleasure to be here. Our office is located in downtown Dayton, and our services are free. So if tenants need assistance in eviction cases or conditions issues or a variety of housing-related issues, they can contact us for assistance. So if you're watching the show and you would need assistance, you can contact us either by phone at 1-888-534-1432, or you can apply online on the web at www.legalaidline.org. So thanks again.
Now, Deb, I was going to wait and give Steve a moment, but this would, I think, be helpful at this point. What might somebody expect when they first call on the 888 number? Because I think over the years, I know I've gotten calls from people and they're a little confused as to whether they're calling to get a lawyer, whether they're going to speak with a lawyer immediately, whether they're going to have their call screened and some information given to them and then some follow-up. Why don't we talk about that before Steve gives his introduction?
Yeah, that's a great question because we surely want to be accessible for folks. So when folks are calling, they're basically applying for services. Because we are free, we serve mainly low-income individuals and seniors, so there's an application process. When they call, they'll likely have to leave their name and a good telephone number to be reached back at, and someone from our legal aid line will contact them and get additional information. They won't initially get to talk to a lawyer, but once their application is complete and it's determined that they're asking for help with a case that we assist with, they'll then get to speak with a lawyer. So it's important to note that we only help with civil cases. We do not help with criminal cases.
And the criminal cases are handled generally by the Montgomery County Public Defender's Office for those who are indigent. Is that
That's
right?
correct. And so oftentimes legal aid does get confused with the Public Defender's Office. They both serve a valuable purpose. Legal aid would be for the civil side and the Public Defender's Office for the criminal side.
That's very helpful. Thank you. Steve, and you can amplify a little bit about what you do and be happy to provide your address of your office and your phone number.
Well, thank you, Jeff. First of all, I appreciate you inviting me to attend this and participate in this event.
My pleasure.
Of course, I've known you for a number of years, and of course, I know Debra quite well through our practices. I'm a local sole practitioner in Dayton, Ohio. I have an office in downtown Dayton in the Barclay building. And I've been practicing law in the Dayton area for over 20 years. Most of my practice is confined to Montgomery County, although I do practice in the surrounding contiguous counties as well. Get down the southern part of the state as well occasionally, but excuse me. But when it comes to landlord-tenant law, most of my law that I practice it's going to be in Montgomery County, Greene County, Miami County, and so on and so forth. But most of my practice when it comes to landlord-tenant is in the Montgomery County area.
And that's generally in the municipal courts, but also on occasion in the common pleas court for that type of practice, right?
That is correct. Most of my practice in landlord-tenant type matters is going to be in the municipal courts, although occasionally I will find myself in the common pleas court as well.
Okay, very good. Anything either of you'd like to add before we move on? Okay. All right. Well, I think we should start with a short discussion about the relationship between landlords and tenants and how that might come about, what laws might apply, and kind of move on from there. So let me suggest this scenario. I'm new to town. I come in. I'm looking for an apartment. And what are some of the considerations that I should be thinking about, and what might eventually we get into with our discussions with a landlord. Deb, why don't you go first? I'm taking this, I guess, initially from the viewpoint of I'm a prospective tenant. Steve, of course, I want you to speak up after Deb does and talk about your thoughts and response relative to the landlord's perspective.
Yeah, so you're talking about a prospective tenant trying to find a home, right? And home is really important to all of us. It's really the center of our life. It's our safe place where we can thrive. And so I think the first thing is that the prospective tenant needs to think about how long they want to stay in that home. And typically under Ohio law, you have a couple things that govern their time there. Their tenancy is sort of the legal term that's used. Ohio law governs that. And then there are a number of statutes that govern that under Ohio law. And then there's the rental agreement, or sometimes called the lease agreement. And so in Ohio, you could enter into a lease for a year, but a tenant may want to think about whether they want to stay at a place for a year, or if they're just sort of coming into the community for a short time. They may want to think about a shorter term lease, something less than a year, or sometimes the most common that I see is a month-to-month lease, where they're just staying, their lease is renewing every month with the payment of rent. So that's sort of the first thing out of the gate you want to think about.
Okay, Steve?
Well, typically, if you're the landlord, excuse me, naturally you want to have a written lease, a written document, and more often than not, the lease is going to be a one-year lease. What I have found over the course of my years of practice is there's a number of documents, fortunately or unfortunately, that are on the internet that get utilized, and those are documents that landlords often use, and they need to be mindful that although they may think they have certain things that allow them to do what they want to do in the lease, ultimately it's going to be the statutes that govern landlord tenant under the Ohio Revised Code. It's going to control that. But nevertheless, a lease is typically is the typical vehicle of choice that a landlord is going to utilize. Have it in writing. It's usually a term lease with a security deposit and of course monthly rent and various obligations of the tenant in terms of could be payments for utilities or what have you. But I always encourage the landlord to have a written lease as opposed to an oral lease, because an oral lease is obviously, can be a he said, she said issue, at least with certain issues. More often than not, if it's rent, that may not be such a critical issue, but other issues that could come up in the landlord-tenant relationship.
Now, that suggests to me, at the risk of sounding self-serving, that it's probably advisable that the landlord, who's generally creating that lease, engages services of an attorney, at least at some point in this process. And by that I mean maybe they have multiple properties, multiple units. They don't necessarily need an attorney every single time they lease an individual apartment in, let's say, in a building of 28 units. But to get the right kind of lease that is fair to the landlord and fair to the tenant, it's probably a good idea right out of the starting gate, right?
Well, my thought is that most of these lease agreements are of the boilerplate variety. They've probably been created somewhere along the line by an attorney. The management company, and I represent a number of management companies.
Okay.
So they have documents that are, I'm sure, have been reviewed by lawyers and have been prepared by lawyers. Okay. But what I caution any landlord is those agreements might contain certain provisions that if push came to shove may not be upheld in a court of law. A good example would be late fees, and this comes up quite a bit actually. The late fee provisions, and I've seen some that are very reasonable and sensible. Some of them that may not be so reasonable and sensible in the sense of what they're asking for. And the law in Ohio governs what the term of art is conscionability. If it's an unconscionable term in a lease, a court can strike it. And what I have found, and this quite frankly more often occurs on the collection side of landlord-tenant, when a landlord is trying to pursue late charges and late fees, a court can strike some of that back if the court considers the court has discretion. If the court considers that those late fees are maybe a little bit excessive, it's not unusual that court will strike it even though it's in the lease.
Okay, so we're going to get to some part of the contentiousness in a little bit. We talk about what might go wrong sometimes. But so that's a general overview as you're moving along and you're just starting. So back to my scenario, I come in, I'm looking for an apartment. Now, there's any number of ways I might look for an apartment online. Looking in the newspaper, I guess, is probably a little old school, but I'm sure there are a variety of ways for looking for an apartment. What might be some of the problems that could result as you're looking? I'm familiar with some of the bad lists, or how individuals looking for apartments might find that they might be excluded either based on a background check or based upon their having been evicted from an apartment, maybe somewhere else. Let's say I'm in Dayton, maybe they came from Cincinnati or Columbus. Can you speak to that a little bit, Steve?
Yeah, I was
and
just,
then Deb?
sure, I was going to kind of get back to that a little bit.
Well, we can get back to that now, or we can do it later if there's a problem.
I was
But go ahead.
just kind of following up on that.
Go right ahead.
When, you know, it's not in most of my clients that I believe, most of my clients I believe, especially on the management side, they have a pretty defined process, for lack of a better word, screening process that they will engage when they are considering a tenant for a unit. And of course, they have to adhere to the various, not only state law, but federal laws as well. And are their background checks done? Of course. They're in a process of trying to get the most suitable tenant, credit-worthy wise, less risk, and so on and so forth. Because you have to remember that the management company is working for an owner. And these owners can live in New York City or Los Angeles, California, or all over the country. And they're entrusting the management company to rent units to people that are going to be less troublesome, quite frankly, just paying their rent. So there are tools that management companies and individual landlords as well, I suspect, can utilize to help screen or assist them in making the right choice for a suitable tenant.
But tenants need to know and understand that this kind of screening goes on, and they need to know, I guess, and again, I think we might be getting a little ahead of ourselves, or I'm getting a little ahead of myself here, with the idea that they may find that something that they thought was in the distant past might come up again, and it could impact upon their ability to rent a unit. Now, Deb, you want to speak to that a little bit?
Yeah, absolutely. So just I want to clarify a couple points. Steve was absolutely correct that a written lease is by far the most preferred type of lease for both landlords and tenants, but then both parties have a clear understanding of what their obligations are. Oral leases are permitted in Ohio, they're legal, so that's just something that folks should know, may not understand, but it does get a little tricky to prove what the terms are when it's oral. As it relates to admissions issues, you're talking about a tenant trying to secure a home. Landlords do use a variety of tools to screen tenants, whether it's a background check for criminal convictions or a credit check for past evictions or owing rent to previous landlords or damages. One thing, though, that landlords need to be careful about, particularly with the criminal background check, is that HUD issued guidance, and HUD is U.S. Department of Housing and Urban Development, in 2016. And they basically said, landlords, be careful of denying prospective tenants based solely on a conviction, a criminal conviction, because there are huge numbers of individuals in our country that have convictions now. They are predominantly African Americans. And if you are denying individuals based solely on their convictions, you could be committing a fair housing violation, because under the Fair Housing Act, you can't discriminate based on race. And so that is one thing that landlords do need to be careful about, and they should be looking more specifically into the conviction and how that would affect the person's ability to rent the unit and the safety of other tenants.
Okay. Steve, you want to respond to that at all?
Oh, no, I would agree. In my practice, I don't believe I've ever had a situation where I've had a question from a landlord about renting to a prospective tenant who has, some type of criminal conviction. But what I do get from time to time is an individual who may have been tagged as a sexual predator. And understandably so, that can cause some concerns with a landlord because of the nature of the offense and how it pertains to the community that this individual is either, sometimes they're already there, and then they learn, the landlord learns after the fact of this incident. So those can be rather uncomfortable, but I totally agree with Debra that you don't want to just prejudge a prospective tenant because of a past conviction, because that tenant may very well be a perfectly suitable tenant, and so you have to be careful to not prejudge accordingly.
Okay.
Yes.
Well, let's stay on the positive side of my scenario, and that I've come in and I've passed some of the initial test thresholds, and we've come to some general agreement before the lease is signed, if there's a written lease. And what should I be thinking about going into that? What should the landlord reasonably be expecting? That would then lead into what the landlord and tenant's obligations are. What does the landlord really need to be providing me, and what does the tenant need to do correspondingly as far as its obligations when the lease is being contemplated? Steve?
Well, I believe the typical process is a tenant applies for a certain, usually it could be a unit's being advertised on a Craigslist, on the internet, through signage in the yard or whatever, or even in the paper. The tenant then, of course, contacts the landlord, fills out an application. There's a screening process. There's a, typically this is, again, I don't rent apartments, but I engage with landlords who do, so this is my understanding of how it typically works. And then if everything checks out and the tenant qualifies financially and qualifies creditworthiness and so on and so forth, they'll have for lack of better words, a closing, where the tenant will come in and they'll sign off on all the documentation, assuming it's a lease. And again, as Debra mentioned, in Ohio, you can certainly have an oral lease, but you want to have a written lease for both parties. But those documents are typically signed, and then in front of maybe one or two people, at least the property manager, and then the tenants are there, and maybe even somebody else from management is there to observe the transaction. And then, of course, it's my understanding typically then there'll be copies provided of everything to the landlord, or to the tenant from the landlord, so that the tenant has all those materials. And then going forward, it's just a matter of adhering to the lease agreement, and not just paying rent, but how you conduct yourself on the property. You certainly don't want to engage in drug activity, because that's a way to get evicted. Take care of your property. Don't disturb neighbors. You have to be mindful you're living, if you're in a community with other tenants, of course, you have to be mindful that they have a certain expectation of privacy in terms of quietness. So how the tenant conducts themselves in the common areas, they don't want to be like doing damage to the common areas or being disruptive or interfering or infringing on the other tenant's use and enjoyment of the property.
And I imagine that one of the key issues too up front is understanding what utilities are provided by the landlord, what utility services, what are paid by the landlord, what are the obligations of the tenants, what happens, and we'll get into some of the events of alleged default or default in a minute or so, but I do think sometimes that needs to be made real clear up front. It should be in the lease, I guess.
It typically is.
It typically is, and the idea is that those utilities need to be paid so that the rental arrangement is maintained, right?
Correct.
Okay. Deb, let's talk about it from the tenant's point of view. What obligations does the tenant have, and what may they have a right to reasonably expect?
Yeah, so let me just talk really briefly about the lease. Lease is a contract, so it's really important as a tenant that you review the contracts before you sign it. And as Steve was mentioning, there are certain terms that are just not allowed in Ohio. They're illegal terms for a lease. So sometimes landlords do use these form leases, and over time they've added terms that are not permitted. So you want to review the lease and make sure there aren't any terms that you disagree with. For example, for payment of rent, potentially you could have a tenant that gets paid every 2 weeks. And their rent is due on the 5th, but based on their history of their paychecks, it would be really difficult for them to pay on the 5th. So you can negotiate that term. You can say to your landlord, I'm not going to be able to pay on the 5th because of how my checks come. I prefer to have it on the 10th. Additionally, depending on...
May I stop you? I think this is important because I've seen this. So there's an oral agreement, even though there's a written lease. And the tenant's understanding is they can pay on the 10th, the landlord, they say, and maybe the landlord has said the 10th, but it's not memorialized. Well, the tenant then is late, and the landlord says late means the 5th, not the 10th, and the tenant says, no, you said the 10th, and the landlord said, no, I didn't, and it's not in the lease. Those kind of disputes arise, right?
Absolutely.
So I guess the question I'd have is, when in doubt, if there's an agreement, put it in writing.
Well, exactly, and I think that's what Debra was alluding to.
Yeah.
You know, there's nothing that says it has to be the first day of the month, and most landlords are flexible. And if you have a payment situation, as Debra is referring to, that's an easy fix. They could just adjust the lease to accommodate that particular due date. And you most certainly want to do that. You don't want to wait until, you know, the event occurs where you don't pay rent on the right, and then you hit a 3-day notice.
And I think this is a really important point because of my limited experience here, and I haven't done a lot of work for landlords and tenants, but in other venues, I've had cause to be involved in these matters. It seems to me this is a good time to just remind both the landlord and the tenant that clear communication and constant communication is so important to maintaining a positive relationship. You have to find the time to talk to your landlord or your tenant. You have to be reasonable about it. You have to have reasonable expectations about when they're available based on both of them, both the landlord and the tenant. And if you expect one side to be fair, you have to be fair.
Yeah.
Correct.
And I think that throughout the more you communicate positively, the more likely it is that the relationship will be maintained. Is that fair?
Yeah, it is. And, you know, just getting back to the lease very briefly, things that tenants want to look out for is make sure that the payment date for the rent is something that they can do, and the location of the payment. You know, sometimes it's a drop box, sometimes they pay via mail, sometimes the landlord picks it up. Sometimes now there's this sort of newer way of paying where folks are paying through a portal. And so for some folks that doesn't work well. They're not technologically savvy, and trying to pay through a portal would be really difficult. So you need to be clear, can I do this, can I not do this, are there other options? And then you want to be clear who's actually on the lease, because that can get into some really tricky situations. Like, am I just on the lease? Is my husband on the lease? Are my children on the lease? So those types of things you want to get to. But your question about the obligations of the tenant, tenants do have obligations. Both landlords and tenants have obligations under the revised code. They're actually companion sections. The landlord's obligations are under 532104. The tenants are under 532105.
The Ohio Revised Code.
That's correct, yes. And so the tenant has obligations to take care of their home. So, you know, have basically good housekeeping, not damage the home. They have a duty to keep things like clean, like their plumbing and electrical. They also have a duty not to sell drugs. They have a duty to not disturb their neighbors' peaceful enjoyment. So when Steve was talking earlier about sort of your behavior in your home, but also the behavior in the common areas, when you're living in, like, for example, an apartment community, you need to be respectful of the other tenants so that they can enjoy their home and not be disturbed.
Okay. Steve, you want to add anything to that?
No, that's correct. And okay, as Debra mentioned, there's a number of it's like a punch list of items that both tenant and landlord, but a lot of it is just common sense. If you're a tenant, you just need to essentially pay your rent, behave yourself, don't do things that are going to hurt other people. And as you're a landlord, you know, you have to run a decent place. And the law is there to protect tenants. In other words, there's a whole number of running water, plumbing, electrical, appliances. A landlord has an obligation to have, buzzword again, habitable conditions. And if that's, so the landlord is also under obligations, as well as the tenant, for the relationship to work correctly.
And I think sometimes what does get tricky is that the parties don't understand the relationship. So the tenant is paying rent to occupy the residence, and that becomes their home. Even though the landlord conceivably owns the property, they've given the tenant the possession of that property. So there needs to be clear communication about when the landlord comes in. The landlord is supposed to give the tenant appropriate notice. Typically it's a 24-hour notice unless it's an emergency. But the tenant also has to understand that the landlord has a right to come in with notice. So even though the tenant is possessing the unit, the landlord still owns the unit, has a right to come in and do maintenance and other things.
And just to kind of continue off of that line of thinking, what Debra says is actually correct, but also because you are renting a property to a tenant, if something does go awry in the process as a landlord, you just can't show up one day, change the locks, and say, see you later. You know, you have to go through a process. You can't exercise or engage in what's called self-help repossession. You have to go through the courts to gain possession back. And although the landlord does own the property, they are renting the property, which creates a legal interest and legal rights of the tenants. And that can become, when you get to an eviction court, as Debra and I both have found over the years, you have two parties that it can escalate in terms of the emotions and the feelings, because part of it, I think, is what Debra said. The tenant has a certain almost ownership interest in the property, and you get that tug of war going.
Well, that seems like a good segue into the dark side of things. So let's suppose I've rented that unit or that house, and things begin to break down between the landlord and me. And the dispute arises, and the landlord feels as though they must take action to evict me. Now, hopefully, there's been some discussion leading up to that. If both sides are properly notified of the issue, and some efforts made informally to work through the problem or problems. But when that doesn't happen, what does the landlord? I guess we should start with the landlord here. What does the landlord do? What are their rights? And correspondingly, what are the rights of the tenant? So if you want to talk about the procedure, the notice, and so forth, go ahead.
Sure, and I'll try to keep it brief and simple, because you could go in a lot of different directions, but the typical and most common problem that comes is when there's a non-payment of rent issue. And it could be for a whole host of different reasons. It could be you have a young couple, that perhaps they split up, leaving just one person there in the unit, can't afford the rent anymore, runs into some financial issues. Or it could just be they could still even be together, and they're just, one of them loses their job. There's a whole host of different reasons that could cause that to happen. In my years of practicing, landlords will try to work with tenants more often than not, unless there's something more than just the non-payment that's causing some problems. If it's a non-payment issue and that only, more often than not, the landlord will try to work with the tenant, maybe accept partial payments, and that's another issue. Maybe accept late payments, again, that's another issue that I could go into in terms of a cautionary tale to landlords. But nevertheless, if it's gone beyond, say, 2 months, non-payment, and it's a real problem, the landlord has to initiate the process by serving what's called a 3-day notice. And again, I get back to the internet, because I've had clients that sometimes they call me up, I've never done any work for them until now, and they'll send me the paperwork, and I always look the notices over rather thoroughly, because that's really where it begins and ends with the landlord. And sometimes they get these notices, the landlord, they get these notices off the internet, and it's not fashioned properly, it's not structured properly, and most importantly, it doesn't have the statutory language that the court has to have in order for the court to have jurisdiction to evict. And so you have to serve the 3-day notice, you have to serve it correctly, meaning in form and substance, and you can serve it by either, most often it's posting it to the door or handing it to the tenant, or even mailing it by certified mail, but more often than not, you want to post it or slide it underneath the door or hand it to the tenant. And then you have 3 days, and then by day 4, then the landlord's in a position to then proceed with an eviction.
What happens if the tenant has responded in some fashion within those 3 days? Does that toll the time for that notice to run? Does that impact upon the process? Do you have to start over again if you try to work something out and it doesn't, and it falls through? What happens then?
And again, you're going into another scenario that happens quite frequently, where sometimes the 3 days come and then something happens, or even after the 3-day notice is served and an eviction action is instigated, but the tenant all of a sudden now has money. Now they're in a position to pay. They want to try to get back to where they were. And the landlord, if they accept funds after a 3-day notice has been served and issued, they run the risk that the eviction can be dismissed. So I always explain to the client, how badly do you want this person out? Because if you really want them out, don't take any chances. You accept the money, give it back to them. But a lot of landlords, they're human. You know, they see the funds, they see the money. They've got an owner telling them, you know, we'd like to see the money, of course. So they may accept it, but may work with the tenant to see if the tenant can come up with the balance. So more often than not, that can work, but it's not advisable if the relationship is such where I want this person out. I guess getting back to your initial thought, once that 3-day notice is served, you can't accept any money after a 3-day notice is served.
Yeah, and if I could just clarify a couple of things that Steve was talking about. So Steve mentioned there are basically 3 discrete ways that this 3-day notice can be served: by posting, by hand delivery, and by certified mail. Those are the only 3 ways under the Ohio Revised Code. In our day of technology, people do all sorts of different ways of serving. So by text messaging, by email. I've had clients get them, this is not so tech savvy, but served on their car, or different ways. So that's not a proper way to serve a 3-day notice. It's just only those 3 ways that Steve was mentioning. And then as
I'll interrupt. Pardon me, I've done this to you twice now, I'm sorry, but on this, I think this is a good point. Can the landlord put in the lease that in the event of an alleged default that they can say that they can serve you with a notice via text message, via email? I would presume the answer is no, because the 3-day notice period is statutory, and that would go against the statutory law, but I would think that that's something that people might consider trying to do.
Right, so I mean, you make a great point, and Steve and I were talking about this earlier, where landlords put things in leases all the time that aren't necessarily legal. And so it's, even if the landlord put in their lease that they could serve their 3-day notice by text message, that wouldn't be lawful, because the statute that sets forth the substance of the 3-day notice and the service of the 3-day notice does not include text messaging as an option.
And I think this might be a good time also to point out, particularly because we live stream everywhere where our live streaming is accepted. Well, I understand from the history of this program that we had callers from all over the country. Not just when you're in doubt, but if you're in Denver, Colorado, and you're watching this show and you're a landlord, you really should make a point of knowing what the law is in Denver, Colorado, because it might be different than in Dayton, Ohio, with regard to so many of the things you're talking about.
Absolutely.
And so just always be careful, back to Steve's point too, about pulling off information off the internet. It may be generic, it may be helpful as a general framework, but when you get into the specifics of your jurisdiction, that's really where you or the management company need to probably review things on an annual basis, and the tenant needs to be as aware as they can be about what their obligations are, but understand and talk about these concerns if they think that the landlord is requiring something that's not permissible.
Yeah, absolutely. Steve was talking about non-payment, which is probably by far the most common reason landlords issue a 3-day notice. And at this point, and probably for the show, we're just talking about market rate housing. So we're not getting into subsidized and public housing, which has special federal regulations that apply to it. But in Ohio is not a pay-to-stay state. So what that means is if a landlord gives a tenant a notice for non-payment, the landlord is under no obligation to accept the rent after they give the notice. Even at the time of trial, if the tenant shows up with all the money that's owed, the landlord doesn't have an obligation to accept it. Some states have what's called a pay-to-stay law, which basically means that the landlord does have to accept the funds if they're paid in full up to the time of the eviction hearing. But if the landlord accepts money from the tenant after they've issued the 3-day notice, that could provide a defense to the tenant if they go to court later on for an eviction hearing. A lot of it depends on whether the rent they're paying covers a past rental period or it covers a future rental period.
Steve, you want to add something?
No, and I agree. I've read case law and I'm not really sure where the courts are with that in terms of the collectiveness. But and I think in the local courts, I'm very cautious. That's just typically the way I practice law. So if a tenant tenders rent, partial or full, after the 3-day notice is served, there's nothing that says the landlord cannot accept the money and work with the tenant. I don't want to mistake in that or confuse that at that point. But if you're a landlord and you do accept the funds after the 3-day notice is served and issued, it creates a potential defense that Debra has alluded to. And my experience is more often than not, it can be fatal to causing the eviction to be dismissed. I believe most of the courts in the immediate area, if they hear from the testimony in an eviction hearing that money's been received by the landlord. Now, if it's maybe a check and the landlord I haven't negotiated it yet, it's just in my office, I'm prepared to return it promptly, that usually will be okay. But even there, I'm always a little bit uncomfortable and a little tentative. My thought is with landlords, if you really want the person out, don't take any risks. Just return the money. If you think the tenant is not that bad and you think you can work with this tenant, then certainly you can maybe take that chance. But the 3-day notice is the most critical part of the eviction process for both the landlord and tenant.
Absolutely, and I just wanted to mention, I mentioned earlier that some landlords are starting to use a portal where tenants can pay their rent online. That can become problematic for landlords if they don't want to accept rent after a 3-day notice is issued, unless they have a way to sort of stop payments. If the tenant makes the payment after the 3-day notice is issued, and to the contrary of Steve, I often advise my clients to make the payments because it is a defense. Then the landlord may put himself or herself in a situation where they've accepted money that they really didn't mean to accept. And at that point, once it gets deposited in the account, there's no turning back. You can't just write a check and say, I'm not accepting it.
And I agree, and I think that's very well said, and that's why as a landlord, you just have to be very mindful of the act of accepting money after a 3-day, whether it's for future, clearly for future, that'll get rid of it. But if it's the argument is, well, we're just accepting money that they owed from 2 months ago, I still am uncomfortable with that. Although I think there's case law that definitely supports what Debra has alluded to. I don't like to. I just simply play it safe, and it would advise the landlord to just return it if you really don't want to risk your eviction possibly being dismissed.
And let me just make the point, if I could quickly, that just because the landlord doesn't accept the rent money doesn't mean the tenant doesn't owe it. So that often gets confused, where tenants will say, well, I offered the rent money, the landlord wouldn't take it, so now I don't have to pay it. Well, from the collection side, the money is still owed. The landlord just didn't take it because they wanted to be able to proceed forward with an eviction.
And I want to move along at this point, just taking a look at the monitor here and the timing here, because I want to complete this process. And I think you can mention something later about escrowing rent and this type of thing that speaks to this issue in part. So let's suppose the landlord has served a proper notice in this, and I think it's instructive that we spent some good time on the 3-day notice process, and as Steve will I think, said, this is really where the rubber meets the road in many eviction cases, and I think you agree that so much time is spent examining that process. But let's suppose the landlord in the scenario with me, the landlord has a problem with me and I'm renting, and so they serve the notice, they serve it properly. What does the landlord do next?
After they serve the 3-day notice?
Yeah, after they serve the notice, the 3 days have passed, no matter has been resolved, what do they do next?
They typically then send it to the eviction attorney to file an eviction complaint in the court that the property is situated in.
The court that the property is situated
Right.
in. And
That would have venue and jurisdiction over that particular property, correct?
And generally that will be the municipal court.
More often than not, but attorneys it's not unusual, some attorneys do file in common pleas.
In common pleas court, I guess. Sometimes you can get a quicker hearing maybe on certain aspects of the case if you go to common pleas, but then oftentimes the filing fees are more expensive. Common pleas court,
Yes.
Is that fair to say?
That is correct. Although the way the municipal courts keep going, they're catching up. But
They're catching up, okay.
Yeah. And it's important to note that just in Montgomery County alone, I want to say there's 8 different courts that you can file an eviction action. So you really do need to know what court what jurisdiction the court has. So often you can call the court and say, I have a property at this zip code, is this the right court? Because if you file in the wrong court and it gets dismissed, you're going to be spending money that you don't want to spend. And if you get a lawyer, they should be able to tell you if it's the right court or not.
Yeah, and I'll tell you a great example is 45414 area code, for example. That could be City of Dayton or it could be Harrison Township, Vandalia. Some of these properties are really right on the line. Or it could be Riverside, which is Area 2, Montgomery County Court, Eastern Division, or it could be City of Dayton. So you really need to make sure you check that. We always, more often than not, we always try to check those. Even though I got good landlords, they send them to me. I still, as a practice, we like to check to make sure we have the right court.
And Steve mentioned that you filed an eviction complaint. Often it confuses tenants when they get served with it because it doesn't say it's an eviction complaint. The term that's used in Ohio is often a complaint enforceable entry and detainer. That's sort of the official statutory language. And within that eviction complaint, there could be multiple causes of action.
Why don't you amplify that? I'm really enjoying this discourse here, but we only have about 10 minutes left. So I will make sure we at least follow through on this and hit the important points. Go ahead.
So typically there's the first cause, which is the eviction part of the complaint. That's the part where the landlord's asking for the property back. The legal term is restitution of the property. And then there could be a second cause. Sometimes there's a third, but the second cause or the causes after the second cause are really just claims for money by the landlord, whether it's back rent, whether it's damage to the property, whatever it might be, pet fees. So that's generally how the complaint is structured. In Ohio, it's really important if the person that's filing the complaint does not own the property. If it's like an entity, like an LLC or a management company, they need to be represented by a lawyer. They can't do that on their own because effectively they would be representing someone else, which is the unauthorized practice of law. It's also important if they are an LLC or a partnership or some sort of entity that needs to be registered with the Secretary of State of Ohio. They have to be registered, even a fictitious name, in order to do business in the state of Ohio. So I can't just make up my own like Lavey rental properties and then file but not be registered with the Secretary of State. I have to be registered to do business in Ohio. So that's really important. And then in the complaint, the landlord has to allege that there's a breach. They have to allege that they're a landlord and that they've served the notice and that the tenant has either breached a provision of the lease that we talked about earlier or that they're holding over their term. So the tenancy has expired and they want them to leave. So that's really important.
Okay. Now, Steve, since I gave Deb a part of your program here, I'm going to ask you to respond. Assuming that the landlord has properly prepared this complaint, they've come to a good attorney to help them do it, such as yourself. You've prepared the complaint, you file that in court, then you have to get that served upon the tenant. And we're not going to focus just on that at the moment because I want to make sure we get through this process here with our time left. We're down to about 6 minutes. But assuming that they do get effective service on the tenant, what happens then?
Well, an effective service typically is by the bailiff going out and just simply posting the complaint and summons to the door. The law was changed, I believe, a few years ago to allow that as being proper service for the first cause only. So as Debra alluded to, it's not unusual.
Meaning the restitution of
Correct.
the premises.
It's not unusual, as Debra mentioned, that a landlord will sue for 2 causes. The second one typically being back rent or other damages, which is a whole nother conversation.
Right.
But for purposes of getting service for restitution, residential service is what's typically referred to, but by the bailiff just simply or a process server, just posting the complaint and summons to the door. And then that's good service. And then of course there'll be a hearing date. And in Dayton Municipal Court, it's typically 3 weeks from the date of the week that that particular complaint was filed with the court. And then there'll be a hearing, which in Dayton Municipal Court is Friday mornings. It could be at 8:15 or 8:30 or even 9:30, I believe. And then they have another docket, I believe, on Thursdays. So it's going to be in Dayton Municipal Court in front of a magistrate in courtroom 1 or 2 on a given Thursday or Friday, 3 weeks out.
It's at 301
West 3rd Street.
West 3rd Street, correct.
Now, again, Deb explained a little bit about the contents of the complaint that you might file. I want you to share with us a little bit about what the tenant might do once they've been served with a complaint as far as defenses. And
sure.
Deb can amplify that a little bit.
Well, sure. If you're the tenant, you most certainly want to talk with an attorney who practices landlord-tenant law, because that attorney is more likely than not going to first of all examine the notice to make sure the notice is correct, was properly fashioned and styled, and does have the appropriate content, as well as the complaint itself. What is it they're evicting you on? I mean, it could be, the complaint may say they have an unauthorized dog on the property, but the 3-day notice was for non-payment of rent. Right there, you got a major problem. If you're the landlord, it's going to probably, you're a tenant, the tenant's attorney is going to be whistling because, you know, you got a dismissal right there. You have to have compatibility. What you're alleging in your complaint has to match what's on the notices. And actually, another issue is the notice itself. There's a calculation of days, and it's you serve the notice, say, on a Thursday, you start Friday, you skip Saturday, Sunday, you skip the weekends, so you pick up Monday, Tuesday. So really, to properly file that complaint would be the following Wednesday, and more often than not, it doesn't work that way. So you most certainly want to see a lawyer if you're a tenant and get some good advice, because, and again, a lawyer who does primarily landlord-tenant law, because they'll know what to look for. And there may be some defenses, but I will note this: if there is a non-payment issue, you may buy a little bit of time, but ultimately the landlord's going to eventually get the property back if there's been significant breaches.
Okay, because the testimony, maybe documents, would reveal that the rent was not paid. Ultimately, if that's the core issue. But under some circumstances, now I want to get back to this issue of escrowing your rent. Mm-hmm. Okay, and we only have about 2 minutes here, and we're going to need to wrap up. But just briefly, Deb, if you could explain under what circumstances the tenant might want to try to escrow their rent while the process proceeds forward.
Yeah, so typically the rent escrow statute is designed for tenants to be able to bring a case against a landlord for conditions issues. And those are issues that, as we mentioned earlier, landlord has obligations under landlord tenant law, and if the landlord's violating one of those obligations and it materially affects the health and safety of the tenant, they can go through an escrow process. There's a number of steps in that. I don't know that we have time to discuss that, but getting back to the eviction case, just to sort of get us through the court proceeding, if there is a hearing, evictions are summary in nature in Ohio, so they move quicker than other civil cases. If the tenant is, there's a hearing for the eviction hearing. If the tenant is evicted at the hearing, the landlord is given what's called an entry of restitution. That's basically the eviction judgment. The landlord then has to pay a fee and file what's called a writ of restitution. That's basically an execution of their judgment. That's to have the tenant moved out. In Dayton Municipal Court, typically the tenant will be moved out under a writ of restitution 7 to 10 days after the eviction judgment is granted. So just to give you a flavor for the timing, really from the time you're served with the complaint to the time you're moved out in Dayton, you're looking at about a month. In other courts, it could be shorter. It could be as short as possibly 2 or 3 weeks.
Okay. Now, we're down to our final 25 seconds or so. And I would love to keep going because this has been invaluable, I think. And I thank you both for being so even-handed. And it just shows what good lawyers you are, that you can really defend or prosecute either side, I think, based upon your experience and your knowledge. So first of all, I want to thank you both for being here and helping us this evening. I want to thank the staff of DATV. I want to thank all the volunteers who've made this possible. And good night.